Last month, the Senate Committee on Environment and Public Works held a hearing on examining the implications of Sackett versus the Environmental Protection Agency for Clean Water Act protections of wetlands and streams. Senator Cramer of North Dakota is on that committee and was at the hearing, and in fact asked several questions of the witnesses. I talked with Senator Cramer shortly after that about the hearing and about WOTUS in general. This was just before the House selected a new speaker, and Senator Cramer and I also discussed the delays in the House and what that could mean for the new Farm Bill. I'm Sabrina Halvorson, and this is the AgNet Weekly. Here is my discussion with Senator Cramer. I wanted to talk about the hearing that was held on the waters of the U.S. and, just this ongoing saga of the waters of the U.S.
Yeah.
What were your initial thoughts on the hearing and what was said?
Sure. Well, first of all, the hearing was set up by the majority to consider the ramifications of the Sackett versus EPA decision, which implies by its very title, oh my gosh, what are we going to do now that the Supreme Court has clarified what the waters of the United States is for us, as opposed to, thank God, the Supreme Court clarified what the waters of the United States is for us. And it was clearly slanted toward the environmental position, and whereas Sackett versus the EPA really was less about the environmental or the pragmatic outcomes and more about the Constitution and the law itself, and so in some respects, like is often the case in Washington, I felt like you had two sides sort of talking past each other, neither one of them necessarily wrong, except that the EPA made a decision. Their job is to make decisions based on whether this fits in this case, the Clean Water Act and the Constitution, not whether or not how much this will either enhance or degrade, the waters, the prairie potholes, for example.
Mm-hmm. And one of the problems from the beginning, years,
yes,
has been a lack of clarity with this regulation. Has anything been cleared up at this point?
Well, I actually think in this particular case, where in the Sackett case, where the EPA, in the Sackett case where the Supreme Court ruled, they clarified a lot. Up until this point, the court has been reluctant to clarify into definitions and prescribe solutions because, of course, it's not really their job. Their job is to make a determination whether the law that was passed or the rule that is codified meets the constitutional and then the intent of Congress, in this case, again, the Clean Water Act. Previous courts have tried to some degree, and one of the things that's at issue here, of course, is the Kennedy consent, where he wrote that there's a federal nexus has to be considered. Well, federal nexus is a very flexible term, shall we say, a very undefined term. In previous cases, in Rapanos, for example, and in Scalia defined a navigable water, a certain way with a little more defined. And it's because the court's reluctant to define for the agencies and for the legislative branch that there's been this regulatory ping pong that would go back and forth. Well, this latest case, the Sackett case, the court did put further definition into what's a water of the United States, remembering that going all the way back to the Clean Water Act in its genesis. Waters of the United States was based on the term navigable. Navigable being, a river that moves up, where you can navigate or move a product from market to market, from state to state, thus interstate commerce. Since that time, the Clean Water Act has come to mean waters that can run into a navigable water. So, a persistent stream or river or a lake, but not a ephemeral one or an occasional one or seasonal waters, things like that. And that's where the definition got cloudy. Well, Alito made it really clear, it seemed to most people, but there's just enough lack of clarity, I guess, in the minds of the agencies that they thought they could sort of stick with this occasional stream, seasonal rivers that could contain some continuous flow during certain times could continue to be considered navigable or waters of the United States. And so in the new rule, in my view, they violated already, the Alito decision and the Alito interpretation of what's a waters of the United States. And I tried to point that out, as you notice, in the hearing rather specifically.
So to give an example of a seasonal water would be an example like during the rainy season when
Right.
something fills up with water and then a little stream is formed, but in other times it's dry, right?
That's exactly right. So exactly right. There are ephemeral streams, and then there are these seasonal streams. Ephemeral being the ones that run above ground for a while, and then they might be underground. They might go into an aquifer, and that aquifer might eventually, bleed into some other stream. Seasonal is exactly what you just described. The kind of feature that in a rainy season, or maybe even in the month of May, might provide a stream to a standing continuous flow of some sort, but it may not. But the court, and this is where we are right now in this discussion about what's a seasonal stream and what kind of a geographical feature that's described or that this might create that creates occasional water. The court really did define that as well, because in his opinion or in his order, Alito referred to these standing or continuously flowing bodies of water forming these geographical features. Then he said, described in ordinary parlance as, quote, streams, oceans, rivers, and lakes. In other words, he wasn't vague. When you use terms like rivers and lakes and oceans, streams, those are things in ordinary parlance, as the court puts it, that we can all understand. We can all see them. We can picture them in our brain, and that doesn't leave a lot of room for the imagination. And yet, the EPA continues to use their imagination to make even more areas subject to waters of the United States, when in fact there should be very few that are subject to waters of the United States.
Right. And you have kind of a unique perspective just as far as regulations go, because you were a state regulator, right?
Right.
And so for our listeners, most of whom are not in North Dakota, can you just tell us a little bit about that background?
Sure. So as a member of the North Dakota Public Service Commission and chairman of the commission for a few years, we cited a lot of infrastructure, right? So pipelines, transmission lines, wind farms, and a lot of that infrastructure was in and around wetland areas. North Dakota being the heart of certainly the northern reaches of the Central Flyway, the Catoctin Prairies, the Prairie Pothole region, and so we're very familiar with permanent water and temporary water, and we're very familiar with things like the EPA's definitions of waters of the United States, or for that matter, USD's definition of a wetland, or for that matter, the Fish and Wildlife Service definition of a waterfowl production area, for example. There are all of these waters that mean something, but they're not all permanent. And over the years and decades, the environmental movement has sought to make everything jurisdictional to the federal government. I've always resisted that for a couple of reasons. First of all, I've never met a farmer yet that thought it was a good idea to not manage their land well and make it sustainable. I've also never met a state that wants to degrade its water supply or its waterways. And so to put everything under federal jurisdiction ignores federalism, and it ignores the fact that not being federally protected doesn't mean it's not protected. So as a state regulator, I always resented the federal government imposing its mediocrity on our state's excellence. And that's where I think a lot of this comes down to. There are a lot of well-intentioned people, and there were, in fact, at this particular hearing, that care a great deal about clean and safe water. They just are, I think, misguided by whose job it is to regulate it. And I think most of the time it's either the landowners or the state's job to regulate, not the federal government's. And frankly, that at the local level, they'll do it a lot better.
Yeah. And that was something I wanted to ask you, and you basically have answered it, is who should govern over this? And you talked about federalism and, and that kind of leads also into another point that I wanted to talk about, national permits versus individual permits.
Yeah.
First off, can you explain the difference for my listeners?
Yeah.
And which way should we go?
Yeah.
And do they work to, is there a way to make this work?
Yeah, actually, a great question, because, again, I think a lot of times people get confused by, oh, my gosh, if the federal government doesn't permit that, or if the federal government isn't regulating that, nobody's taking care of it. The reality is that federalism isn't a one or the other. I like to refer to cooperative federalism. In other words, there's a partnership here between the federal government and the state jurisdictions. And to some degree, when you talk about a national permit, that includes townships and counties and municipalities as well. So a national permit, there's actually a thing called the national permit. A national permit applies largely to interstate linear types of infrastructure, such as an electric transmission line that maybe runs from a power plant in the center of North Dakota, or a wind farm, in the prairies of South Dakota, and runs across multiple states. And it might be a natural gas pipeline, or an oil pipeline, or a water pipeline, or it might be an interstate highway that runs across multiple states. In that case, there's a process for a national permit from the U.S. Army Corps of Engineers that governs the entire infrastructure, rather than going state by state and jurisdiction by jurisdiction and federal nexus by federal nexus. It's hard to have a long interstate linear infrastructure that doesn't have some federal nexus, because somewhere along the line it's going to cross a waterway or federal land, or some other protected area, in which case it's just a lot more efficient for the applicant to get one national permit rather than to get a whole bunch of either national federal permits and or state and local permits. So there is a place for a national permit. It creates what I call regulatory efficiency. It also recognizes interstate commerce, and it's just a whole lot easier for an applicant, because we still need all of this infrastructure to have a growing economy, to get our products to market, and to recognize, again, one of the very few things that the federal government is actually, authorized to do as per our Constitution. That's govern interstate commerce.
So where do we go from here? And that's kind of always the question that I ask whenever I do an interview on, the waters of the U.S. or the Clean Water Act is, where do we go from here? What are you hopeful for?
Yeah. So a couple of things. First of all, the Sackett decision was so clear in my mind that obviously this newest interpretation, this newest effort at a new Waters of the United States rulemaking will be litigated again, and in my view will be overturned again. And if necessary, the court will either even further define what, in fact, a navigable or a waters of the United States is. And I don't know how you make it much clearer, but they can probably make it even a little bit clearer. The other thing, and the more appropriate thing, would be for Congress itself to write a more prescriptive law and to amend the Clean Water Act, or to pass some sort of addendum that further defines waters of the United States in a way that recognizes the limits put on by the court and by the Constitution, but also makes sure that that water is protected as necessary. And that would be probably more sustainable, more durable than a court definition. But it shouldn't need to be. It shouldn't need to be, but clearly it will be. It'll also be very difficult for Congress to do that, because, as you might have noticed, we are a very narrowly divided Congress, and because we're a very narrowly divided country, and yet I think we all benefit from a little bit of certainty. So who knows? We'll see if we can't take another whack at it in Congress, but I'm almost certain that the court will get another shot at it.
Yeah. I think you're probably right about that. Can we switch gears for a minute?
Sure.
I want to get your take on the Farm Bill. Obviously, you're in the Senate, not the House, but with all of the everything going on in the House and the search for a speaker, obviously there's going to be more delays for everything, and that does include the Farm Bill. What do you see happening with the Farm Bill, and do you think that is there any hope of getting a Farm Bill this year? And if not, what should happen?
I think it's getting more and more unlikely that there'd be a Farm Bill done yet this year. It's not impossible. There's still enough time on the clock to do it. There's some political will to do it, but as you point out, the dysfunction in the House makes it literally impossible for them to deal with it because they can't even have significant committee meetings and certainly can't conduct any committee business in terms of a markup or anything like that. That said, one of the ideas has floated around for a long time, but Senator Bozeman, the ranking Republican on the Senate Ag Committee, has suggested a 1-year Farm Bill extension. And that's probably appropriate in this case because one of the things we don't like to do, there's a time for deadlines and cliffs and there's a motivating factor to all of that. But farm bills have generally been pretty, amicably debated, if you will. As you know, there's a lot of mandatory spending in farm bills. There are a lot of mandatory programs in farm bills, and there's even a little bit of a check and balance in terms of how the permanent law kicks in if a new law is not passed. So there are plenty of incentives for us to get our work done. But another year might be useful in putting some of these things together and putting them on paper while we wait for the House to get its act together. Largely because the current Farm Bill, or really the last 5-year Farm Bill, is still pretty good law. And I think agriculture by and large, and more importantly, the extension of agriculture being the banker, can live pretty well with an extension of the current Farm Bill, and certainly much better than one that actually runs out of money and runs out of authorities, which happens. I don't mean to get super wonky on all this, but the Farm Bill is built in a way that, as you know, to run for 5 years and then either be changed or extended. But there are parts of the Farm Bill that run calendar years, so they run January through December, and parts of the Farm Bill that run during the fiscal year, and so we have some of that. We have some of that overlap going on right now with our continuing resolution. There's quite a bit of money in the system, and so farmers aren't really feeling an immediate pinch. But as you prepare for next year's crop, your banker and your insurance company, they all want to know what the rules of the game are going to be. And that's why I think a 1-year extension would provide that certainty over the course of the next 10 to 12 months, while we could work on a farm bill that wouldn't require all 10 or 12 of those months perhaps, but at least there would be that certainty so that the business of agriculture could move forward.
Yeah, which is probably eases the minds of those in the ag industry around the nation.
For sure. Yeah. And the sooner we do that, in my view, the more breathing room we get, and the more breathing room that those that are planting, as you know, just because you might plant in the spring, depending on what, spring comes depending on, for different people in different parts of the country, but we're to that point where the planting is well underway, even as harvest, the last things are being harvested right now in the Great Plains. Those things are being determined right now, and those discussions are taking place between farmers and bankers. And as you know, we have the additional inflationary costs of inputs, and we have higher interest rates, and so all the more reason for certainty and early planning to take place. So we need to provide, I think, that breathing room.
Yeah. Anything else that you'd like to comment on? Those were all of the questions that I had for you.
No, but I've never been so glad that I decided to run for the Senate and not stay in the House.
Can I use that?
I was uncertain for a while. Sure, you can if you'd like.
Thank you once again to Senator Kevin Cramer of North Dakota. This is the AgNet Weekly. I'm Sabrina Halvorson. Thank you for tuning in.